Hi, welcome to the Civic Podcast. Talk about business and AI. We're going to go over OpenAI's recent filing for an application for complex designation in regards to Elon Musk's lawsuit against them. Then we're going to go into Sam Altman's trying to get a chip factory built in the Middle East, and then Mira Morty's snafu in her interview with the Wall Street Journal. So if you like business and AI and comedy, hit that like and subscribe button. The show is hosted by two former Googlers. My co-host is VP of Eng. He's currently buying another island in Hawaii. He's up to like 2,000 right now. It's getting pretty crazy. I am a mergers and acquisition specialist, and let's get into it. So it took me a minute to find the documentation for this. So defendant's application for complex designation. So this was filed on March 6th. I thought it was a pretty interesting document. Now, I'm not a lawyer, but Krista is, and Krista's probably listening, so she can correct me wherever I get this wrong. We get this wrong in a lot of different places. But OpenAI is asking for a dismissal. That's number one. They don't want this thing to go to trial. But two, they're filing this because they want to show the judge that like what Elon's asking for is going to take a lot of court resources. So if we go through with this case, we want to make sure we have as much of the court's time as possible. And it's kind of a way of implicitly letting the judge know, like, you really should consider dismissing this, but if you don't want to, you're going to be wasting a lot of the court's resources and our time also from all our parties. So let's go through this. Through earlier support and board member of OpenAI, plaintiff earlier supporter and board member of OpenAI, plaintiff Elon Musk quit the company years ago and started his own for-profit AI business. Were this case to proceed to discovery, the evidence would show that Musk supported a for-profit structure for OpenAI to be controlled by Musk himself and dropped the project when his wishes were not followed. Seeing the remarkable technological advances OpenAI has achieved, Musk now wants a success for himself. Shots fired. So he begins this action accusing defendants of breaching a contract that never existed and duties Musk never owed, demanding relief calculated to benefit a competitor to OpenAI. Ooh. So they're basically saying that there's this contract never existed about what OpenAI status should be, and what Elon was saying about this is always going to be a nonprofit. Musk purports to bring this suit for humanity, when the truth evident from the face of Musk's contradictory pleading is that he brings it to advance his own commercial interest. According to the complaint, all defendants entered a founding agreement with Musk, promising him OpenAI would never operate for profit and release all its AI publicly. Promises all defendants purportedly breached by, among other things, licensing OpenAI's core GPT-4 technology. Musk further claims that all defendants breached fiduciary duties and engaged in unfair business practices by using early contributions Musk made to OpenAI for purposes supposedly inconsistent with the alleged founding agreement. There is no founding agreement or any agreement at all with Musk, as the complaint itself makes clear. Ooh, interesting. So basically, this doesn't exist. The founding agreement is instead a fiction Musk has conjured to lay unearned claim to the fruits of an enterprise he initially supported, then abandoned, then watched succeed without him. Of course, this is OpenAI's interpretation of facts. Elon could have a founding agreement or somewhere. The documents Musk cites as purportedly memorizing a binding contract with him. OpenAI, certificate of incorporation, and a few emails. On their face show no promise to Musk. So they're saying what he's basically trying to prove his case is just fluff. There's nothing real there. The pleading nowhere alleges that Musk's early donations were conditioned on defendants following a specific business plan, nor could it. The relief Musk seeks is extraordinary as his claims are contrived. Musk requests an order compelling OpenAI to reorganize and distribute its technology in accordance with the terms of his fictitious contract, and he wants a judicial determination with an accompanying mandatory injunction that certain OpenAI technology constitutes artificial general intelligence, having intelligence for a wide variety of tasks like a human, when it does not. Okay, so let's read this one more time for the kooks watching. And he wants a not everyone here is kooks. It's 0.01%. Don't forget to like and subscribe. 0.001%. And he wants a judicial determination with an accompanying mandatory injunction that certain OpenAI technology constitutes artificial general intelligence, i.e., having intelligence for a wide variety of tasks like a human, when it does not. So basically, OpenAI is saying here, no, Jimmy Apple's a smoking crack. We don't have AGI. So like, and I know what's going to happen next. But the one other is saying this because it's a trial. AGI really exists. Well, if Musk is seeing this right now, and he knows for certain there is AGI inside, we'll have Krista here, but you could push for proceed, try to get this case proceed. You could go back to the judge and be like, here's actually proof AGI does exist. They're lying to you now, which now OpenAI is lying to the court, so they've perjured themselves, and so that's terrible. So if Elon has this information, he could basically trump card them right now, or he knows it, but could go. We'll have Chris talk about this, but in discovery, if it does prove that they actually do have AGI, then like, ooh, not good for OpenAI. But basically, OpenAI is saying they don't have AGI, so that probably is not going to lead to YouTube videos speculating the end of YouTube videos speculating about AGI, but it's interesting for them to put it in this document. They do not have it. Frivolous though Musk's legal claims are, exceptional judicial management is warranted to ensure this case is litigated efficiently, expediently, and fairly. Pretrial motion practice will be intensive. The facts Musk purports to put at issue are complicated, highly technical, and span nearly a decade, and the relief Musk seeks extraordinary, and if granted would require ongoing supervision. These factors weigh decisively in favor of a complex designation and assignment for all purposes to this court, a complex civil litigation department pursuant to California Rule 3400. Basically explaining to the judge, like, if we proceed with this thing, it's going to waste a lot of the court's resources. It's going to be onerous to both parties. This might be a complete waste of time, which from what I've seen from both sides, it looks like this thing's a waste of time. So let's go here. Under the California Rules of Court, a complex case is one that requires exceptional judicial management to avoid placing unnecessary burdens on the court or litigants, and to expedite the case, keep costs reasonable, and promote effective decision making by the court. So yeah, so that's about it for this. There was one more part. If you go down to page 5, it says, finally, Musk's request for extraordinary relief entailing substantial post-judgment judicial supervision counsels in favor of complex designation. The complaint requests a suite of truly extraordinary measures calculated to benefit Musk, whose own for-profit AI concern has not met with success in the marketplace. Musk asked for an order of specific performance compelling OpenAI to operate and disclose the technology in accordance with the terms Musk has conjured, a judicial determination that GPT-4 constitute artificial general intelligence, and other forms of atypical mandatory injunction relief. Where this case to move forward beyond the pleadings and must prevail on any of his claims, none of the relief sought will be proper or warranted. But navigating the issues raised by the prayer for relief in this case would benefit from careful attention to a dedicated judge. They also mention here, on page 4, let's go to this here. Complex designation is also appropriate given the high likelihood of serious and consequential discovery disputes in the event this case proceeds beyond the pleading stage. Musk competes directly with OpenAI. Were discovery to commence, Musk would use the suit to seek access to OpenAI's proprietary records and technology and to press for broad merits of discovery. Those demands would need to be carefully policed through the resolution of discovery motions. Given the technical facts Musk purports to put at issue, expert discovery and attendant disputes will be expected as well. So they're basically going to the point of like, Musk has a lot to gain if he could get more information on how OpenAI operates and how their models work, because he has a competing model out there. And for OpenAI to prevent that from happening, they would have to run all of his requests through their legal team, which would lead to obscene amounts of billable hours and everyone losing for him just fishing for a lawsuit. So I thought that was really interesting. Love to hear what you all think about it.